filed my writ of my special appearance. Okay, and let's read it. Rick, I wanted to give you an update. I went to court on Wednesday. I filed the notice of special appearance and writ of habeas corpus void support order. I was literally the last case on the docket. If you ever watch a lot of videos on YouTube from people that are, who don't know how to defend themselves in the court, this is a practice. They always put you last in the docket because they don't want you enlightening anybody else. They don't want anybody sitting in the seats watching you go at these people, and they get ideas. Joe from Hawaii Cop Watch. Anyway, he arrested him, and what he did was he got a contempt of court bullshit, and he sat while he was in the jail cells. He was screaming and educating everybody. So he made them pay. So he was teaching everybody how to fight themselves. That's another thing. Like if you want to avoid jury duty, just tell them that you're a sovereign citizen or something, and they'll get rid of you. Because they don't want you teaching the other jurors the law. They want all of us as dumb as possible of the law. That way they can destroy us and steal all our money. Right? I mentioned the other day about ignorance. They rely on ignorance. That's how they make a lot of money. Okay? So he just said, he was last case on the docket, which was done strategically. Then she took a 30-minute recess and came in and told me she wouldn't be hearing the case that day. My baby mother had a lawyer. The lawyer wanted jail time. Look at the audacity of this piece of shit. Like he has the right to order him to be arrested, jail time. And a lump sum immediately. She demanded me to be arrested then and there. Wonderful ex-wife, or ex-girl. The judge refused to do either. I wonder why. The lawyer and my baby's mother were beyond possessed. He meant to say possessed. The judge then tells me she's giving a chance to get a lawyer or legal counsel. You know what that's all about? She doesn't want to deal with him anymore. Okay? So this is going good. And said to reschedule for next month. Now, you know what this was all about? Now, this is for everybody out there. If you ever deal with something like this, you must resubmit the same paperwork again. So what they do a lot of times is they don't want to deal with it now. Then they hope by rescheduling it, they hope that you're not going to resubmit it. And it's not on the docket anymore. You understand? So they don't want it to deal with a special appearance. Okay? So I told Ozzy to resubmit it. Okay? All right. Reschedule for next month. She ignored to address the jurisdiction and then told my ex not to worry. She has a good lawyer, meaning like that her lawyer is good. Like, whatever. Her ex's lawyer. Which I thought was very unacceptable. It is. It's not, actually. Okay? That sounds like, to me, like she's not being impartial. Okay? So anyway, ask me for any suggestions. So let's go on. Okay, so let's look at this one. And I gave him a response. He goes, Rick, I can't lie. She locked up the guy before me, and it scared me. Her lawyer is charging another $2,000 to go back. I know. All right. So he didn't. What I said to him was, and this is what all of you I want you to do. If any of you are in the same position. You have to demand a dismissal right then and there. What you're doing is you're giving the judge is waiting for you to see how you're going to respond. So if they're pulling this, they don't respond. They're supposed to respond with the evidence that we're demanding for with the special appearance. You have to say, I demand a dismissal for default, lack of jurisdiction, lack of evidence. All right, that's what I told him to do. Okay, but that's a good sign. That's a special appearance, and look what happened. The judge locked up somebody right before him, and the judge was treating him with kid gloves. Okay, so all right. So let's take a look at what the special appearance looks like. Okay, Hold on a second here. All right, this is what it looks like. Special appearance. We cover everything. Okay. All right. Here's another thing. Oh, let me use this one. What I want you guys to do from now on also is put in support of your paperwork. It's called a memorandum. It's a notice of course, a memorandum of laws, judicial cognizance. What happens is when you give the court a law that applies to your case, they have to take cognizance of. It's called judicial cognizance. Okay, let me look it up. Well, let me show you how I do things sometimes. All right, let's go into. All right, let's go into Google Scholar here. All right, so what you do is you click on select courts, right? Hold on a second here. I screwed this up because I didn't want to see the name of this guy. But anyway, what you do is you clear all, right? And what I do is I just click on Supreme Court. You see that? Then you click on Done. So now anything I put in here is only going to be for the Supreme Court. So let's just put in judicial cognizance. Now what you could do is you could put it in quotation marks. That way, because that way you catch just that phrase together. Sometimes only judicial come up or cognizance comes up. All right. Let's see what happens here. All right. So right here, there we got case law, judicial cognizance. So you click on the case law, right? Here's another thing. It says how cited, and it shows you how it was cited. And it shows you it's cited by all these different courts. All right. But let's go back and look at the case again and see what it says. Well, I just gave you, because I didn't obviously jurisdiction. All right, so obviously I didn't plan this out too good. But anyway, what I just did is I showed you how to look up things for, let's say, for any specific court. So let me just show you also. So I just showed you how to do it for Supreme Court, right? Let's say you just want to do it for your state, right? You go back to select courts, right? All right, we clear all everywhere, right? So let's just say you live in Missouri, right? You click on Missouri, you click done. So that means in your state, you can click on stuff. That's how you find stuff in your state. All right, so let me go back and show you one more time. All right, clear all, federal courts, state courts. All right, you live in Alabama. You click on Alabama. See here? Click done, and in here, only court cases from Alabama courts come up. Okay, so this is a nice little tool. All right. All right, so let's get back to the definition of judicial cognizance. And I apologize about the way the screen looks, but I'm not that good with the computer stuff, with these graphics and all this other stuff. It took me forever to figure this out. Remember, I used to just use my camera. But listen, I know the law. That's all that matters. Okay. I have a very good understanding of the law. All right, so, all right, judicial cognizance, Google search, right? Black's Law Dictionary. The term given is the judge must act on regardless of the fact that is not proved in evidence. All right, this is good. What they get? All right, there's the Latin phrase, the term given to the information that a judge must act on, regardless of the fact. So again, we use this. We're telling the judge with this to take judicial cognizance of these laws. Now, right? Article 1, that's writ habeas corpus. Article 4, Section 1, full faith and credit. All of these laws here. And then I put in all these case laws. All right? And the judge is supposed to take cognizance of this. All right? Very nice. All right, so here's another thing. Where the fuck is it? All right. Here's another thing I got for you guys. It's called objection, demand clarification of evidence. A lot of you are getting back these responses from these judges where it's just a one line, you're denied, lack of merit, denied, or just whatever. We're going to file notice of court objections. A lot of times, again, I get annoyed because a lot of you guys, you've been watching the videos for a while, and you're like, what do I do next? What do you think you do? You file an objection. It's the immediate thing. Next thing you need to do is file an objection. Okay? You can't file an appeal until you file an objection. You got to exhaust all your remedies. Okay? So we got to exhaust the remedy. So what are we going to do? We're going to file an objection. As soon as you get that bullshit, you file an objection demanding clarification of evidence of what? Of an injury in fact to dismiss, redress, and remedy. All right? And we throw in some case laws in there. Whereby, without clarifying evidence of an injury in fact, this court is without jurisdiction to deny the undersigned respondent's demand for dismissal. Okay? It's really simple stuff. You could, when you're inside the court, objection. What happened there with Ozzy earlier? He should have said objection. The court must grant the dismissal. They did not. We got to remember something. I want you guys to understand something. You guys are the respondent. You do not have the burden of proof. The burden of proof is always on the claimant, the petitioner, or the plaintiff. They're supposed to bring the evidence, not you, the respondent, defendant. Okay? But they got us with this child support. They got all of us on the defensive. All right? I just had a guy today email me. He's like, Rick, help, I'm in court. They're trying to make me take the paternity test. What do you say? No. Under the Fifth Amendment, you do not have to give testimony against yourself or provide evidence against yourself that can hurt you. All right? I've used this example before. Watch that show on A&E, 48 Hours, right? And they're investigating murders, right? And they got a guy in the room and they think that he's the guy. Do you see them ordering him to take a DNA test? No, they know that they can't. If a crap, that they might try, but if a guy he knows the law. And here's another thing. Watch that show. Who always usually walks out of that room, even though they believe them to be guilty? It's the guy or the girl who keeps their mouth shut. So that goes for you too. Keep your mouth shut when you go to these court hearings. Objection. That's it. You should either say objection, I rest on my paper, demand for dismissal. Again, objection, clarification of evidence. All right? You should not be giving them any, I sent her a check, or we had an agreement, or, Your Honor, I can't find a job. But no. Objection. Okay? These are the things you got to do. You didn't do anything wrong. You don't have to give testimony against yourself. Like I said, you're not there to defend yourself. They're supposed to provide the information. So you should be saying, Your Honor, I'm paying, here's another thing. You could just say, we had an agreement. I watched the kid. You don't have to pay with money. Let's just say you lived out in the woods. You could go out and shoot a friggin' animal and feed your child that way. You understand what I'm saying? The courts have recognized that. All right. Anyway, listen. This is a mishmash video, just to show you that this right here, the special appearance, is getting a good response. Okay. This Ozzy could have ended up in handcuffs, and he didn't. All right. They treated him differently, and they're trying to give him an attorney. Whenever they're trying to give you an attorney, all right, don't take it, because when you take an attorney, you are considered feeble-minded. All right, you become a ward of the court, and the court does not recognize you. You ever notice that you try to speak? Sir, you can't speak. You have an attorney. You're done. Once you get an attorney, it's over for you. I don't know if anybody'd ever beat a case for child support because they had an attorney. The best case scenario is let's say you owed a bunch of money for arrears. All right, maybe they get the arrears cut in half or whatever, but you're still paying. Okay? All right, so listen, I'm going to cut this short. Again, if you need to contact me to make a donation, it's Rick, RICK 0327. All right, I'll talk to you guys later.